The cameras flashed, the crowd froze, and just like that, Hollywood had a new obsession.
Oh, it was everywhere.
Literally everywhere. I mean, imagine launching an album that sells like 5.5 million units globally in its very first week. You are completely dominating the cultural conversation. Every stadium is sold out.
Right, your merch is just flying off the digital shelves worldwide.
Exactly. And then the entire machine threatens to just grind to a halt. Because a cabaret performer who plays 90-seat dinner venues and golf resorts in Nevada claims you are erasing her identity.
That sounds like a total paradox.
It really does, but it is currently playing out in federal court. Someone sued Taylor Swift, and her lawyers just ended them.
They really, really did.
Welcome to StarScope Report. Join us as we uncover Hollywood drama, music industry shakeups, and viral influencer scandals. From red carpet surprises to social media controversies, we dive deep into the stories behind the fame.
And today's deep dive is, it's a massive one.
It's huge. And hey, if you are loving these Hollywood twists, make sure you're subscribed because we have got even crazier stories ahead. So today we are unpacking the intense legal battles surrounding Taylor Swift's massively successful 12th studio album, The Life of a Showgirl.
Which dropped in October 2025.
Yes. And we're going to look at the two distinct legal arenas she's fighting in. First, the copyright claims over the actual music, and second, this rapidly escalating, super high-stakes trademark war over the album's title.
Right, the trademark war is wild. We are looking at a masterclass in how intellectual property law operates when, the scales of power are just wildly unbalanced.
But I have to ask, is this just the inevitable tax of being the biggest pop star on the planet? Like, are we at a point where every single note and word a megastar publishes gets put under a legal microscope by people looking for a payday?
Well, to really answer that, we actually need to look at the music first. Because before getting into the courtroom drama over the album's name, there was this immediate backlash over its sound.
Oh, I remember that.
Yeah, it perfectly illustrates the difference between what feels like copying to a fan versus what actually is copying under the law. Shortly after that October release, fans and critics and reports from places like Variety started flacking these similarities.
Social media was flooded with them.
Exactly. Specifically, listeners compared Swift's title track, Life of a Showgirl, to the Jonas Brothers song Cool. And then her track, actually Romantic, to the Pixies' alternative classic, Where's My Mind?
I saw those side-by-side audio mashups everywhere on TikTok.
Oh, they were viral.
Where someone plays like 4 seconds of Swift, then 4 seconds of the Pixies, and declares the case closed. And honestly, to the average ear, it feels like an obvious theft.
It does. But the courts, they do not listen to music the way a fan on TikTok does. They filter it through this concept called the de minimis doctrine.
The de minimis doctrine.
Right. It essentially means the law does not concern itself with trifles. So in copyright law, protection is reserved for highly original, creative expression. Basic elements like chord progressions and simple rhythms are considered unprotectable building blocks of music.
They just live in the public domain.
Exactly. For example, while actually Romantic shares a chord progression with the Pixies, it's E, C-sharp minor, G-sharp, and A in the key of E. Major experts agree this just isn't enough for an infringement claim.
I always think of this using an analogy of primary colors for visual artists.
I like that.
Yeah, like you cannot copyright the color blue. You can only protect the highly specific painting you make with it. If we actually allowed artists to copyright basic chord progressions, wouldn't that effectively bankrupt the future of pop music?
It absolutely would. We'd literally run out of legal songs to write within a decade. There are only so many ways to arrange a finite number of chords that sound pleasing to the human ear.
Right.
So from a compositional standpoint, the music itself is safe. But selling the music is only a fraction of the modern pop star's revenue model.
Yeah, the real longevity and the massive profit margins live in the marketing and the physical merch.
And that transitions the problem from the music itself directly to the trademark battle.
But wait till you hear what came next. Because while the copyright complaints didn't have legal legs, the fight over the album's title is a completely different story.
This is where Maren Wade enters the picture.
Yes. A Las Vegas performer who goes by the stage name Maren Wade. On March 30th, 2026, she filed a federal trademark infringement lawsuit against Swift.
And this wasn't just a frivolous claim. Wade holds a registered incontestable trademark from 2015 for Confessions of a Showgirl.
12 years of hard work. She started it as a 2014 column in the Las Vegas Weekly, got some traction on America's Got Talent, and evolved it into a touring cabaret show, a podcast, and a book.
Right. And the conflict started because Swift applied to trademark The Life of a Showgirl. But the U.S. Patent and Trademark Office, the USPTO, actually suspended and initially refused her application.
Wait, really?
Yeah, they cited potential confusion with Wade's existing mark. But despite the pushback, Swift's team, which includes UMG Recordings, Tia Rights Management, and the merch company Bravado, they just ignored it.
They moved forward anyway.
Yeah, releasing the album and all the merch across global retail channels. So Wade is suing for treble damages, disgorgement of profits, and an immediate injunction to stop Swift from using the title.
Those are serious penalties. Disgorgement means handing over the actual profits made from the merch.
Which is millions.
Easily millions. And her attorney, Jamie Parkkinen, is arguing a concept called reverse confusion under the Lanham Act.
Yes, reverse confusion.
Okay, let me translate this with a real-world analogy. This sounds like a mom-and-pop coffee shop getting totally squashed because Starbucks accidentally gives a new global frappuccino the exact same name.
That is the perfect analogy.
Even if Swift had no ill intent, doesn't the sheer overwhelming scale of Swift's brand practically erase Wade's 12 years of hard work overnight?
That is exactly what Wade's legal team is arguing. Her brand identity is basically being swallowed whole by this billionaire's marketing machine.
Wow. Later in the episode, we will talk about the shocking twist nobody saw coming with how Wade actually handled this online.
Oh, it completely changes the dynamic.
It really does. Stay tuned and hit that subscribe button so you don't miss what's coming next, because you will not believe Swift's response.
It was fierce.
It's one thing to claim your brand is being erased, but how does a billionaire's legal team respond when a local performer tries to freeze their massive empire with a very, very aggressive counterattack?
Swift's legal team at Venable LLP filed their opposition to Wade's requested injunction on May 6, 2026.
Just a few days ago.
Right. And they called the lawsuit absurd. They called it a meritless attempt to grab a marketing boost.
Ouch.
Yeah. And they laid out three main defenses. The first was the First Amendment. Swift's team claims album titles are expressive works protected by free speech.
But Wade's lawyer fired back at that, right?
He did. It was brilliant. He wrote in his brief, "Defendants assert First Amendment protection for napkins and hairbrushes."
That is such a good point. A song is art, but a $40 plastic hairbrush is commerce.
Exactly. So then Swift's lawyers moved to their second defense, which is scale and fan knowledge. They basically mocked the idea of market confusion,
Pointing out that Wade's shows are at 55-plus golf resorts and 90-seat dinner venues.
while Swift is doing global stadium tours. Plus, they argued that Swift's fans are legendary for decoding complex Easter eggs and numerology.
Oh, so they're saying the fans are too smart to be confused.
Right. They would never accidentally buy a ticket to a Vegas dinner theater thinking it was a secret Taylor Swift show.
That is actually a really clever defense, but the third defense is the one that really blew my mind. And that's not even the wildest part.
No, the third defense is Wade's complicity.
Wait, if Maren Wade is actively using Taylor Swift's music and hashtags to promote her own show, isn't Swift's legal team absolutely right?
That's exactly what they proved. Swift's team provided over 40 examples of Wade posting on social media after the album's announcement.
Using Swift's music.
Yes. And using hashtags like hashtag Swifties and hashtag DS12.
To promote her own cabaret show.
Yes.
How can Wade sit in court and claim her brand is being irreparably harmed when she's visibly trying to go viral off Swift's coattails?
Legally, she can't. To get an injunction, you have to prove immediate, irreparable harm. You can't claim someone is destroying your brand while you're simultaneously using their fame to boost your ticket sales.
That completely undermines her whole case for the injunction.
It really does. But, the public reaction tells a slightly different story.
Oh, totally. I mean, we've seen how this is playing in the court of public opinion. On forums like Reddit, specifically the Travis and Taylor subreddit, small creators are actually cheering for Wade.
They are. They feel like Swift is finally getting a taste of her own medicine.
Because Swift's legal team frequently uses automated bots to aggressively issue bulk takedown notices against independent Etsy sellers.
Right, for using basic generic phrases. These bots just scrape platforms and issue copyright strikes.
And the platforms just shut the small creators down immediately to avoid liability. So you have all these independent artists watching this lawsuit, feeling like Roe v. Wade is fighting a proxy war for them against corporate bullying.
It really highlights the power imbalance. But realistically, a hearing is set for May 27 in Los Angeles.
And legal experts note the likelihood of a full trial is, like, infinitesimal, right?
Yeah, a settlement is highly probable. Swift's team will likely just pay her to make it go away so they can keep selling merch.
which perfectly highlights the incredibly tricky balance between an independent artist protecting their life's work and a megastar claiming First Amendment rights to express their art and sell their work.
Definitely.
So I want you, the listener, to reflect on how you view intellectual property rights when the scales of power are so wildly unbalanced. Does the law actually protect the little guy? Or does might make right?
It's a tough question.
It really is. And as we move further into a future dominated by global mega brands and automated copyright enforcement, I want to leave you with a final provocative thought to mull over.
What's that?
Right now, this battle is between a human pop star and a human cabaret performer. But we are rapidly entering an era of generative AI. What happens when artificial intelligence algorithms begin generating, registering, and mass trademarking millions of catchy phrases, band names, and album titles every single day?
Oh, wow.
If a mega corporation can unleash an AI to legally claim ownership over vast swaths of human language before independent artists even have a chance to write a song or start a podcast, who actually owns our culture?
Are we heading toward a reality where every common phrase is owned by a corporate giant?
Exactly. Will there be any catchy, generic phrases left for independent artists at all?
It is terrifying.
It is. The legal paperwork hiding behind the curtain of pop culture usually dictates the future of art long before the artists even realize it.
So true.
You've been listening to StarScope Report, where we uncover the stories shaping Hollywood, music, and pop culture.
Thanks for tuning in.
And don't forget to subscribe for more stories that keep the stars shining.